Welcome back. Today we're inside a courtroom where the stakes couldn't be higher. We're starting with a case that'll make your blood boil. An 80-year-old scammed out of 12 grand. The judge isn't playing around today, and neither am I. Stick around, because this defendant is about to face a pay up or pack your bags ultimatum.
Court is correct. There was a federal prosecution.
Excuse me just a second. All right, I can see you're pregnant, so there's no need to
I'm not trying to show
Okay.
that off.
All right. The person who's 80 years old and you scammed them out of $12,000, they're probably on a fixed income. They worked all their life to save that.
I'm sorry.
1 moment.
All right.
Oh.
And if she chooses prison, it doesn't hurt my feelings. I understand when people have issues that are going on in their life, but they haven't seen you since 2021. Why would this be any different than before?
Your Honor, I'm old.
Credit card abuse that's open, a felony credit card abuse, a felony theft, 2,500, 2 or more times open, a felony fraud, another credit card abuse open, another credit card abuse open, another felony theft open, an aggravated robbery.
Not a cheer for Texas Tech.
No, you don't. No, there's
Yeah.
no requirement.
No, Kelly is saying yes. You are going to have to
That's one
debate.
reason not to cheer for Texas. Judge,
There's going to have to be a debate, right?
as long as the Longhorns are out, I'm happy.
Ooh.
Yeah.
Ooh.
Short horns.
And have you talked to Jason Garhan
No.
about what is he, Texas A&M?
Isn't it?
Yeah.
It's kind of a cult.
And has somebody talked to Notre Dame? They're still upset.
You have deprogramming for all the A&M fans.
I don't even know if I should take this up because of Oklahoma.
You know, do it for my dad.
Oh, okay. All right. I'll do it for him. He has LSU roots. And your mom. Their love story was so great. You know, your sister told me about their love story.
So, but then by my dad getting arrested.
Yeah, she told me about that. And I can joke with him. We've known each other forever. All right. The court is calling 2023 CR 5888 State versus Anaya Gifford. Can I have parties announced for the record for the state?
Megan Galloway for the state.
For the
Power for defendant, Your Honor.
And are you Miss Gifford? All right. You entered a plea of guilty on October 16th.
Let's talk numbers. Restitution. That's legal speak for pay them back. The defense is trying to argue that because she's already paying into a massive $1.2 million federal pot, this $12,000 local debt should just blend in. In the legal world, federal and state debts are different beasts. The question is, where is an unemployed defendant getting that kind of cash?
There was a request for a PSI. And according to your plea bargaining agreement, punishments be assessed at a cap of 8 years in the prison. There's a $1,000 fine. The state is opposed to your application. And there's restitution of $12,000 to Mr. Holtzworth. Have both parties had a chance to review the PSI?
Yes, I've reviewed it, Your Honor, and I have no objections.
I don't have any objections, Judge.
All right. And are there any witnesses?
The state has no witnesses, Your Honor.
No, Judge, I just have an argument.
All right. The court will hear argument. State you're opposed.
I am, Your Honor. I'm asking for the court to deny the application and sentence her to 8 years and reserve the rest of my time.
All right. Just one moment. All right. You may proceed.
So, Judge, I want to point out, from looking at this, Ms. Gifford was sentenced to a federal prison for a conspiracy charge that I think this case arose out of. She was released, I think, actually with a warrant in place from the federal penitentiary, and then made bond here. And I don't know why this was not included originally with the federal prosecution, or if in fact I don't have a copy of the federal PSI, and I can't really determine whether or not the complainant in this one is actually a complainant involved on the federal case. And if the court notes, there's a restitution amount among all the people who were sentenced of $1,235,000. Ms. Gifford's currently paying restitution to federal supervised release, which is the federal equivalent of parole for this the federal charges. And she's employed now. She lives in Georgia, and is capable of of paying restitution on this case. If the court grants her deferred, obviously it would have been better for her if this case had been included in the federal sentence. And I think how much
I got sentenced to 57 months and I served 30 months.
so if the court doesn't grant her application, I ask the court to give her credit for the time she spent in the federal penitentiary, since this is in fact, I think, out of the same fact pattern, and I think the same conspiracy. But I would ask that she's been released, and she's paying restitution now, that the court bring her probation and her pay restitution on this case as well. Like I said, I have no way of determining what restitution was ordered. I would assume it's jointly and severally among the conspirators, but I don't know if the complainant in question on this case was one of the complainants on the federal case.
All right. And my understanding in this case, and correct me if I'm wrong, I'm going from memory. This is a case where the complainant was told that their grandson was
That's correct.
in
That's right.
dire straits and that they needed someone to take their money. I'm sorry, they needed someone to withdraw money to save him from the dire straits that he was in.
That's correct.
All right. All right. State.
Judge, so what Mr. Mauer represented to the court is correct. There was a federal prosecution.
Excuse me just a second. All right. I can see you're pregnant, so there's no need to
I'm not trying to show
Okay.
it off.
All right. Thank you. You may continue.
There was a federal prosecution that occurred out of San Diego, and the court is aware of the $1 million restitution that they were ordered to pay out of San Diego. I didn't have anything to indicate that this victim was included in that. However, this was a very big conspiracy that they put together where they were targeting elderly individuals. The victim in this case is 80 years old and was targeted because of that. Called and told that his grandson was in danger and that he needed to spend $12,000 immediately to provide safety to his grandson. And the $12,000 is agreed upon. The evidence did point back that it did go into this defendant's Chase bank account. And in the stipulated evidence, the Chase bank records are in there where the account is belonging to Anijah Gifford, Your Honor. And so we would ask that you order the restitution if you do give her community supervision, but I just don't believe that she's a good candidate for community supervision. So we would ask that you deny the application.
All right.
Wait for it. The judge just flipped the script. She's using the empathy trap, asking the defendant how she'd feel if her mom was a victim. It's a classic tactical move to see if there's any real remorse. But then comes a hammer. February. You have until February to find $12,000. Do you think she can pull it off, or is she headed straight to a cell? Drop a comment below.
I'm not saying I'm going to deny it or grant it, but when are you going to have this $12,000?
If I'm being honest, I can't give a specific date, but I can make payments, whatever you order. If you order for me to make a specific payment, I can work on that.
All right. Here's my question. Do you have any loved ones?
Yes.
Mom, dad? All right. Let's assume that someone's picking up the phone and calling you and saying, hey, your mom has been in this accident and we're going to arrest her unless $12,000 is paid. Right? So look at that as that type of urgency. So when are you going to have this $12,000? Because I can tell you, and your attorney can probably tell you, the person who's 80 years old and you scammed them out of $12,000, they're probably on a fixed income. They worked all their life to save that. and you came in because you didn't want to get a job and you wanted to build your happiness off somebody else's misery. So I want to know when you're going to have this $12,000. And I can tell you the latest is going to be in February.
I can do that.
I think that's a good idea, Judge.
All right. And I'm not saying I'm going to grant it, but what I'm saying, that would probably help your case tremendously because he needs his $12,000. So, Ms. Ferguson, recall this for sentencing in February, and you need to have the $12,000 and you need to be here in court.
I will be here.
All right.
I'll get her to sign a reset form.
All right. Thank you. We'll see you back on February 2nd. At that time, you need to come with $12,000. And state, does that need to be in cashier's check, money order?
And usually there's an upfront restitution form we have to fill out.
I can do that.
All right.
Yes, ma'am. Thank you.
You're welcome. Plea bargain agreement with the state. You've applied for deferred adjudication and also for community supervision. According to your plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. This is the run concurrent with 2024 CR 2272. State will take in consideration 2025 CR 008992. Have both parties had a chance to review the TAP evaluation and PSI?
Yes, sir.
Yes, Your Honor.
Any objections from either party?
No, stay here.
Just a few corrections, Your Honor. I've reviewed it with my clients, and you have a copy of it.
Yes.
On page 1, although this goes more towards argument, guilt minimalized, on the PSI specifically is for the firearm. I believe what they're referring to is for the case that's being TIC'd, but she admitted there was a firearm. And for argument, I will explain further for that, but she didn't minimalize the handgun. She acknowledged there was a handgun. On page 2, everything's correct on page 2, but on page 3, under other cases outside Bexar County, Kendall County, Texas, she said that there was no state jail prison trip on Kendall County.
Okay.
It was only one state jail trip on page 2, one TDC trip on page 2, and she didn't have a third trip to prison. Same page 3, Tarrant County, just so the court's aware, April 9, 2025, under Tarrant County, Texas. She was in custody here. It's a typo. It should have been 2015. If you look at the convicted 180-day jail, 11/23/2015. I just don't want the court to be thinking that she had a out-of-county case April of this year when she didn't.
Okay.
Also, page 5, where it says unemployed, she did report that she's self-employed. She has her own landscaping company. She's able to provide for herself if she was to be granted probation. On page 6, it says that she although to the left it says none for DWI education, to the right it says yes, which could be for AANA. She has done AA. She just wants the court to be aware that she's never had a DWI. She's never had to take DWI education class. And page 9, although this is not really a correction, it's just so I can point out, they wanted proof of full-time employment under other within 30 days and provide proof of education within 30 days. She's saying that she received 2 GEDs, one in Arizona, one in Texas. In 2001 and 2017, she did have a GED. The 2017 was in Bexar County Jail. Aside from that, there's no other corrections, Your Honor.
All right. State, you're opposed to the application?
Yes, Judge. Yeah, again, I don't have any evidence.
Okay. All right. Anything your client wishes to say?
Yes, Your Honor. I would like to call her, but if I can do some argument first. We were here previously. Okay.
I think it's best that I take testimony and then I'll allow both parties to do argument.
Can I call Audrey Bash?
Yes. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing?
New case, same story. Me, Tawdry. She says she doesn't want to be in jail, but the judge just hit her with the ultimate reality check. Then why do you keep doing this? Audrey's taking 19 classes in jail, more than most college students. But is it genuine growth or just a desperate attempt to look good for the bench? What do you guys think? Reform or performance?
But the truth so help you God. All right, you can lower your hand.
Ms. Bass, you're currently on probation supervised from this court. Yes?
Yes.
All right, you need to speak up so the court reporter can hear.
And you're asking this judge to grant reinstatement and probation on this new offense?
Absolutely. Yes. Yes. Yes.
You're willing
Okay,
to
so here's the thing. I can barely hear you. You're a distance away from the court reporter. I know the court reporter is struggling. You need to speak up.
Yes, ma'am.
Yes.
you're willing to do anything this judge imposes at you for probation?
Absolutely.
And
Then, I'm sorry. Then why haven't you been doing it? Like people always say, I'll do whatever you want me to do on probation. You're already on probation. In your statement on page 7, it states, when asked why she felt she should be granted probation, the defendant stated, it's hard to be in jail. I don't want to be here or in prison. If you don't want to be in jail and if you don't want to be in prison, then why do you keep doing this?
I was doing my classes. I was told to do the IOP classes here. I did 18 out of the 20. The day I came to jail would have been my 19th.
But we're here for a new case. That means that you picked up a new offense.
Yes, ma'am.
So why? Why do you keep doing this? It seems like you want to go to prison.
I do not, ma'am.
Then
I know to be better, I have to do better. And since I've been in here, I've done every class that they could give me. I'm trying to do better. I
here's
do
the thing,
understand
people
that.
always do better when they're in jail. Normally, I will have people, they come before me, and when they're in the free world, they don't do what needs to be done. When they're in the jail, it finally hits me, oh, I'm in jail. And then they start taking every class they have at the jail, as evidenced by the fact that your counselor is saying, I've done my GED twice, when you only need to do it once. But people always become focused when they're in jail because they don't want to go to prison or they don't want to be in jail. So my question for you, why would this be any different than before?
Your Honor, I'm old, and I know that I just don't want to do this anymore. What happened was I let fear control me and make a bad decision, and that was wrong. I was being threatened.
So how old are you?
42.
So you've had this MTR since last year.
No, ma'am.
Well, you were placed on probation
In
on 2024.
September, and
So, I mean, you were maybe a year younger than you are today.
and I was really trying to do everything that I could, and I do believe that I can do better. I if given the chance, I know that I can do better. I can be better. I can do better. I do
Your Honor,
believe that.
the threatening that she had, she is a victim of robbery. I tried to find it. I went back in time on YouTube to try to find it. There's a case here, family violence. Rick is familiar with. I've asked Rick to pull up the case information. He couldn't find it. I was in court here, and there was a Spanish sentencing, and there was a person who was very loud, talking in Spanish. I don't speak Spanish, but when the state had said that there's multiple victims, that lady was sentenced to prison. They said that the restitution was owed to Audrey Bash, but they didn't know her location at the time. I've asked them to try to find that. I couldn't find that case. I don't have a way to search that. But she understands that a gun is not supposed to have a gun on felon probation. If she were to have a gun after the 5-year period elapsed after she was discharged, cases ended at her house for protection. But she had some bad relationships. She had struggled. She had a relapse. She wants to be a licensed clinician, dependent counseling to help other addicts recover. She believes she can stay sober. And she won't be around firearms. I've never had somebody take upwards of 20 classes at the jail. People usually take 2 or 3. And she not only took, I think it was 19 classes, but the AA meetings and 10A meetings she's done, it's multiple. It's not just 1 or 2. she's actually participating. She's not crossing her arms, defiant. She's willing to do probation. It's her first MTR. I know that there's 2 new offenses, hoping that can give her a chance.
All right, state.
Yes, I did have some questions for the defendant.
Oh, you may proceed.
Ms. Bash, so you were placed on felony probation in September of 2024, correct?
Yes.
Okay. And so as part of your conditions of probation, you were supposed to report to your probation officer. Do you recall that?
Yes.
Okay. And so it would appear that the last time that you reported to your probation officer was in February of 2025. Is that correct?
No, I didn't. March also, I was in my class and my teacher, we reported by phone.
I'm talking about going to the probation officer and meeting with your assigned person at the field office. Okay, so the last time you did that was in February 2025, correct?
Yes, ma'am.
Okay. And the address that you provided to probation at the time that you were placed on there was 1126 King Avenue, apartment 6. Were you living at that address up until your arrest?
No. Yes, no, ma'am. I had moved, but I told them my mother.
Okay, and what was it? You told them your new address?
Yes.
Okay. Now, as part of, because you are on felony probation for drug possession, you acknowledge that, right?
Yes.
Okay, and so part of the conditions that the court placed on you to help address this issue is for you to go to partake in your analysis. You recall that, right? Okay, and so you had been ordered many times. So starting in January 2025, you did report to provide a urinalysis. Is that correct?
Yes.
And that was positive for amphetamines and marijuana, correct?
I believe so.
Okay, and then in February of 2025, you did not appear to provide a urinalysis, correct?
I don't remember. I don't remember being told to do it that day.
You don't remember being told to do it that day? Well, I guess it's fair to say the last time that you did it was in January of 2025, right? So the last time that you provided your analysis was in January of 2025?
Yes, ma'am.
Okay. And so then in your PSI, you deny that you were under the influence of any alcohol or drugs at the time of your new arrest. Do you recall that?
Yes, ma'am.
But when we look at the stipulated evidence, the officer states that when he approached you,
Ouch. The prosecution just caught her in a massive lie. Audrey claimed she hadn't used meth in 10 months, but a drug test say otherwise. In court, credibility is currency, and Audrey just went bankrupt. When you lie to your investigation officer, you're basically handing the judge the keys to your cell. Watch how the energy in the room shifts right here.
appeared to be sleeping in your vehicle. Do you acknowledge that?
Yes, ma'am.
Okay.
It was raining and the roads were wet and I pulled over rather than getting in an accident. I fell asleep driving one time before and I killed myself. And I would rather not do that again. I wasn't on drugs because if I had been, I would have been awake.
Okay. And so
I
what
did
is this that
something
the officer is saying that he could smell marijuana in your motor vehicle?
I was asleep. I wasn't smoking, I was asleep.
So when was the last time that you smoked marijuana in that vehicle?
I don't remember.
You don't remember? Okay.
And I don't think it was me. I think it was the person that I let my car to. Earlier that day.
Okay. So then further in your PSI, you state that the last time that you had used methamphetamines was 10 months prior to your arrest. Is that what you said?
I believe so.
Okay. But you were found in possession of methamphetamine on the date of the offense, correct?
I did not know that it was there. If it had been mine, it would have been on my person. I would have known that. I didn't know that it was in the floorboard of my car because I gave somebody a ride to work. It would have been, in my possession. I really did not do that.
Okay. Well, notwithstanding you disputing those facts, okay, you were arrested in May of 2025 and had a positive UA while on felony probation for methamphetamines in January 2025. So please tell me how many months that is. It's 5, right? Not 10. So you're not being truthful to your PSI officer or this court about what you're doing on felony probation, correct?
Yes, ma'am.
Okay. And then further in your PSI, you're stating that you should be granted probation because you don't want to go to jail, not because you want to change or not because you want help, correct?
I want help, ma'am. I would like help. I'm trying to be a better person. I'm doing everything that I can to be a better person.
Okay. So if you wanted help, why did you not reach out to your probation officer, or why did you not show up to your UAs, or why did you not show up here to the court to ask for that?
I was doing the classes, and I was doing the classes that they gave me, the IOP classes here at the probation office. I had reached out to my teacher and told her that I was having a hard time, but I was doing that. I mean, I thought that there would be a record of that.
Did you notify anybody that you were actively engaging in using controlled substances besides your IOP teacher?
No, ma'am.
Okay, because you understand that the IOP teacher is not the correct person to report that to. It's your probation officer, right?
Okay.
You understand that?
I'm doing that. Yes, ma'am.
And so I guess ultimately what you're telling this court is that you just don't want to go to jail or prison because it's hard, right?
No, ma'am.
That's what you stated in your PSI, right?
And it's not that's not it at all. I would really like to be given a shot to be a better person, to do better, to prove to myself and the court that I can do better. Prison is easy. I mean, you do what they tell you to do, and that's it. But when I've done probation. I've free and cleared probation with no violations. I've free and cleared parole with no violations. I believe that I can do better. I truly do.
This is the ultimate choice. Door number 1 is 10 years of strict supervision. Door number 2 is 5 years straight in prison. Audrey chooses a 5 years. Why? Because sometimes looking at a decade of doing the right thing is scarier to a habitual offender than just doing the time. We're moving on to our final case, a man who skipped probation for 3 years. Let's see his excuse.
I want to be better. I know to be better, I have to do better. And I'm prepared to do that. I know that probation is very rigorous, and I'm prepared for those things. Anything that you give me, and I'll be happy to do. I want to be better and do better and help others be better and do better.
Okay.
I believe that.
Well, would you agree with me that given your history, the state and this court has already given you a chance by placing you on felony probation? And here we are, because you cannot violate or you cannot abide by the terms of felony probation. You'd agree with me, right?
I believe that I made a mistake once, and I would really just beg mercy to please get a second chance.
When you say that you've made a mistake once, I mean, this is not the first time that you've been charged with a criminal offense, correct?
Mm.
So that's more than once, right?
I'm asking for a shot, a second shot from this, but I don't know what to say there anywhere. She's
May I briefly
Ask the
respond?
witness.
All right. So I'm going to give you a choice today. These are your choices. There are no other choices. 1, I can place, you say you want the help. I'll give you deferred adjudication. The state is offering you a cap of 6. If I give you deferred adjudication, the full range of punishment is open to the court, which means up to 10 years in the prison. You are not going to ISF. I don't think ISF is appropriate. You'll be at the jail waiting transfer to SafeP. And the SafeP program is a 9-month program. And then you have aftercare for 3 months. Or if you would like, I'll sentence you to prison. I'll sentence you to prison for 5 years. Those are your only 2 choices. Which do you choose? And see, this tells me right now, she really doesn't want the help, that she's trying to figure out back time. But you can discuss it with her. No, those are my only 2 those are your only 2 choices. There are no other choices. You can either do 5 years in the prison, or either you are going to do 10 years deferred adjudication. Those are your 2 choices. No other choices for you. So which do you prefer?
I'm sorry.
One moment,
All right. And if she chooses prison, it doesn't hurt my
Your
feelings.
Honor.
Yes.
We're ready to proceed forward. She has her answer.
So which does she prefer?
5 years TDC, and we would ask that would run concurrent with her MTR. We would ask if you would reform the judgment of the 10-5.
Oh, just 1 second. We haven't done that case yet. All right. So in cause number 2025 CR 008991, the court will sentence you 5 years in the prison. I'm sorry. The court is going to find you guilty, sentence you to 5 years in the prison. Give you credit for any time served. This will run concurrent with 2024 CR 227. I'm sorry, is this 2272 or what? 2272. Take in consideration 2025 CR 008992. And I'll request the therapeutic community. Is there anything else in that case with regards to sentencing?
Yes.
All right, we're going to proceed in 2024 CR 2272. And that cause number, you previously pled true to violation of condition number 1. The court found violation of condition number 1 true. And your range of punishment on that case, the court could sentence you anywhere up to 10 years in the prison. And state, what are you requesting?
Judge, we are asking for revocation and 5 years to run concurrent with the prior cause.
That's our recommendation. We ask that you follow it. I've previously conferred with Megan. If there was revocation, we would ask you to reform the judgment to match the sentence.
All right. Are you waiving your right to appeal? Okay.
Well, thank you, Judge.
All right. And that cause number, the court is going to sentence you to 5 years. You credit for any time served. This will run concurrent with 2025 CR 008991. And the court will request the therapeutic community. State, you may be excused. Thank you. It's your view, the document. All right. Good luck to you.
Thank you.
You're welcome. Placed on deferred adjudication in 2020 CR 10239 for the offense of assault, family choking, strangulation on February 9, 2021 for a period of 3 years. Is that you?
Yes.
All right. State.
This morning, we're here on state's motion to enter adjudication of guilt and road community supervision. Violation condition number 5, in Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there failed to report to the supervision officer as directed for the months of August and September 2021 in violation of condition number 5.
All right. To that, how do you plead? True or not true?
And what do you say?
Yes.
True. Yes.
All right. So you seem a little bit unsure. So the state is saying that you didn't report for the months of August and September in 2021. Do you understand that?
Yes, she was the one that usually sent me a text or a call to let me know like it was on Zoom.
No. So here's the thing.
It's true. Or true.
Yes. So sometimes when people plead true, they plead true and then they say, hey, judge, no, I didn't report, but I have an explanation. You understand?
Yes, ma'am.
So you've heard states reading a violation of condition number 5 that they're saying you violated.
Yes, ma'am.
All right. To that, how do you plead? True or not true?
True.
All right. State.
For the original motion to enter adjudication of guilt, we will waive the remaining violations and we will now proceed on the supplemental motion, Your Honor.
All right.
Violation condition number 5. In Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the months of October, November, and December 2021 in violation condition number 5.
How do you plead to that? True or not true?
True. Violation condition number 5. In Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there failed to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2022 in violation condition number 5.
How do you plead to that? True or not true?
True. Violation condition number 5. In Bexar County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2023, and violation condition number 5.
How do you plead to that, true or not true?
True. Violation condition number 5. In Bear County, Texas, the defendant, Ricardo Anthony Salas, did then and there fail to report to the supervision officer as directed for the month of January 2024 in violation condition number 5.
How do you plead to that, true or not true? And state, do you waive the other violations?
I don't believe there are any others on the supplemental.
Well, you're correct. All right, any objections to the state's waivers to the other violations?
No, ma'am.
All right, did you understand by pleading true to violations 5, 5, 5, 5, 5, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 5, 5, 5, 5, and 5?
Yes.
The court will find 5, 5, 5, 5, 5 true. Is there a proposed agreement?
There is not, Your Honor. We're both going to go to the court for our recommendation.
All right, state, what are you requesting?
State's requesting a revocation of defendant's probation, adjudication of guilt, and 3 years TDC.
And defense, what are you requesting?
Judge, obviously I have a different recommendation. I don't know if you want me to give it to you now. I have one witness that I would like for you to hear.
Oh, come up.
Is that okay?
Yes.
Okay. Mr. Ibanez, his name's Justin Ibanez.
Okay.
And as he's walking up here, I don't intend on calling all of them, but if you're here for Ricardo, can you stand up, please? I just wanted the court to know that he has his grandmother, mother, and siblings all here in court to death.
All right. And what is your name, sir?
Justin Ibanez.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. And if you can lower your hand. And you said Ibanez?
Ibanez, yes.
How do you spell the last name?
Ybanez.
All right.
And yeah, on top of the N too.
Okay. I don't know if the court reporter has that symbol she can put. All right. Defense, do you have questions, or did he just want to let the court know some information?
He does, Judge. I just wanted to ask him this one question. Just if you could tell Judge Boyd, how long have you actually known Ricardo?
Since elementary, if I could remember. Yeah, like 4th and 5th grade.
A long time.
Very long.
So you have
15 years.
Sorry, you have prepared a statement you would like to share with Judge Boyd about Ricardo.
Yes, I do.
Okay, good. You can do that.
Good morning, Your Honor, and the people of the court. I'm here today for Ricardo Anthony Salas and to tell you the type of man he is. We both grew up together most of our lives, and I can say he is one of the most hardworking men I've known. He's very dedicated to his family, a great family man. Not only have we grown up together, but we've had similar tragedies. Both of our fathers have passed away just months apart. And as we are here today trying to follow in our father's footsteps, to try not miss a second of our children's lives by sending them away for so long will not be beneficial for him or his family, as it can have an effect on his kids for the fact that he was always there, never missing a day of their lives, with Zoe doing cheer, Naya taking her to school every day, and being the ultimate babysitter for baby Ricky. These past months have been very hard on the children, and I know that he can change his ways for the better, to be a better citizen and hardworking for his family and kids who he loves very much. Thank you, Your Honor.
All right. Thank you so much.
All right.
All right. Any objection to my asking a question?
No objection from the state.
All right. So this is what I want you to realize. And I keep an open mind when everybody's on probation, right?
Yes.
Because sometimes people have things that happen, and I understand. Where has he been since 2021? Because we're in 2025. And I want you to understand, he's on probation.
Mm-hmm.
And the easiest thing to do is report. And I tell everybody, if there's an issue, you can always come to this court and discuss the issue with me. But according to what he's just played true to, nobody's seen him since 2021. And I understand when people are like, great, I'm living my life. I'm not picking up any new cases. But being on probation, there are conditions with that. There's no such probation where the probation is you're on probation and I'm just going to disappear, because otherwise, why do we have probation?
Yes.
So where has he been? Do you know?
He's been in the same place since 2020, or he moved down the street to his dad's, and he's been working there.
But did you know he was on probation? Did he let you know that?
I did, but I thought it was dismissed because they stopped talking to him. They stopped reaching out.
Okay. All right. Thank you so much for coming in and giving me some insight into him. I really do appreciate it.
Yes, thank you.
All right. Thank you. Any other witnesses?
There are no other witnesses.
All right. You can come forward. All right. So, Mr. Salas,
Ma'am.
I appreciate the fact that your family is here. I appreciate the fact that you have witnesses who are coming in to support you, right? But the easiest thing to do when you're on probation is report. I mean, that's easy. And so the issues with you is any objection to the court reviewing the court summary?
No, not at all. And I do have some comments for the court that I don't think appear in the summary at the appropriate time.
Okay. Well, I'm just going to give you my thought process. And then, of course, I will still keep an open mind, right? So the problem is nobody's seen you since 2021.
Mm-hmm.
And then according to the court summary, you haven't completed anything. Is there anything that you've completed on probation other than just, I didn't pick up any new offenses?
Just the family violence class.
All right. They're saying here that you have not completed the BIP, the parenting classes, or outpatient treatment.
Okay. Can I just tell you my side of the story real quick?
Do you have any objections to? All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record. All right, so why didn't you report?
All right, so we're 8 months into it and everything going good. And then I had my mom in the hospital from COVID. This is all during COVID. I had my mom in the hospital. I just had a newborn son, and then my dad passed away. I'm not trying to come with no excuse or anything, but I just hoping for like an understanding that I wasn't trying to like not report or anything like that. I was going through so much, Your Honor.
Well, so here's the thing.
Mm-hmm.
You haven't reported since 2021. We're in 2025. So I do understand when people have family members to pass away, when people have family members very ill. I understand when COVID was going on, but you didn't even pick up the phone in 2022. All right. And now, COVID. Okay. 2023, 2024. All you have to do was pick up the phone and call probation. I understand when people have issues that are going on in their life, but they haven't seen you since 2021. And according to this court summary, you didn't do the BIP course. This is an assault family violence case, so you need to do that.
Okay.
According to this, you didn't do the parenting classes, and you didn't do outpatient treatment. So have you done any of those?
I started like 2 or 3 classes when I think of the Zoom meetings.
Mm-hmm.
I'm not too sure how far. I know I started right away. Being in jail, ma'am, I'm sorry. It opened my eyes to like I should have caught it. I should have done other things other than not caught.
Yeah, everybody. Let me just tell you, a lot of people have an eye-opening experience when they go to jail.
Mm-hmm.
Or when they go to prison. They're like, now I see.
Yes.
But it's not as though you're a teenager. You're an adult, so it shouldn't take that.
Gotcha.
And everybody, you can't be on probation and not be on probation. And what I mean by that is you have certain conditions you have to follow.
Yes, ma'am.
And your condition can't be, well, I didn't pick up any charges. It's not like in municipal court where they give you deferred and they tell you just don't pick up any new cases and you'll be fine. Okay. Yes.
Can I add on?
Sure.
So I had the exact same dialogue with Mr. Salas. He did tell me about his situation, and I think early on he got off to a decent start. And then COVID did affect his entire family. He did lose his father to COVID, and his mother was very, very ill. And as I understand, the probation department was there in the home. At one instance, the mother was very ill with COVID, the father had already passed. The file documents all of this, and I asked Ricardo the same thing. Like, I understand 3, 6, even a year of your life being so affected by your loved ones, but at some point you're going to have to come back into the fold. And as so often happens, I think you fall into a hole that's up to your knees, and you just let it continue, and before you know it, it hits your chest. And then 2 years later, it's over your head. And I'm not going to say he just kind of gave up, but I think at that point, he just kind of understood that he messed up. And it was the wrong response. So there's no justification for it. There is no good answer. The only analogy that I can kind of give you that I think might, resonate with you is, I know that you're a college football fan, and, you have your team, and one day your team comes out, and they're a good team, they're a great team, and they lose a game they shouldn't lose, and they play terrible, and they can't do anything right. But you don't give up on them. And the next week they come out and they beat the Aggies or somebody like that. And Ricardo's, the Aggies. Ricardo's kind of like that. He's a good guy. And talking to him, he is. I've seen pictures of his children. He's a very good father. He works and supports them. He didn't go anywhere. He just didn't call and get caught back up. And I told him, had you done that, we wouldn't even be in this boat, most likely. What I'm asking, and it's a big ask, is the court can put him on a regular probation. I do believe and know that he can do the things you ask him to do. And jail, it's an eye opener, but it's a bit of a cop out, because you're right. In jail, hell, I'll do anything or say anything. I don't want to be in jail. I don't want to go to prison. Do I believe that he will do the things you want him to do? Absolutely. I do. I've talked to all these people behind me. He's got that. He's got great support. And I told them, you got to get on him. If he's, you got to stay on him. We should never have gotten this far, but we did. And so the prison, of course, it'll be there waiting for him. And my ask is that you take him off deferred, put him on regular, and let him do all the things that he still needs to do and will do. I can't explain his actions. I know part of the beginning, but the rest of it, he just screwed up. There's no excuse. He screwed it up and he knows it. But he wants to make it right, and I believe he can. And so I'm hoping the court kind of sees that in him and allows him to do that.
All right. So I want you to know that I listened to everything that everyone said. I've internalized everything. However, I just don't think you would be a good candidate for probation because nobody's seen you since 2021. Please, yeah. I'm sorry. So I'm going to revoke, find you guilty. There's an affirmative finding of family violence. I'll give you credit for any time served. Does anyone want to speak to time? State is requesting 3 years.
I mean, obviously, Judge, I'd ask the court to recommend the minimum term if possible. He does not have that much time in. He does have 4 dependent children. They're going to be suffering alongside him too. I don't believe he has. I don't recall his history prior to this, but I don't think I don't think there was anything else there. So the court could recommend a minimum term sentence, Judge. That's what
Your Honor, I'll do anything to put on probation. I'll finish it, Your Honor. If it's to add a year or 2 to my probation, I'll finish it, Your Honor. I will. I'll do whatever it takes to not be in there anymore. I'll finish it, Your Honor.
All right. This is what the court is going to do. The court is going to, as previously stated, revoke, find you guilty. There's an affirmative finding of family violence. The court will give you credit for any time served. The court will sentence you to 3 years in the prison, and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a right to appeal. It's a limited right to appeal as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right. Yes or no?
Yes.
All right. We can go off the record. So here's the thing. When you go to prison, you better show me something. Your attorney will explain that to you. Do you understand? All right. And what is this on the side?
That's entirely younger.
All right. Make sure you get a doctor to check that out, okay? And your attorney will talk to you about everything that I've said and what it means. All right. Thank you.
Thank you, Judge.
You're welcome.
Person let's go through your stuff. So at the outset, it looks like you're wanted out of state for one reason or the other. I have no idea. I know you're going to tell me it's all gumdrops, tulips, and little bunnies jumping, right? But how I get to know you is how you look on paper, right? What I see now, you have a credit card abuse that's open, a felony credit card abuse, a felony theft, 2,500, 2 or more times open, a felony fraud, another credit card abuse open, another credit card abuse open, another felony theft open, an aggravated robbery. Is that it? And then what else you got open out of state?
She has 2 theft of properties from Houston County.
No kidding.
Yes.
What would you like? A unicorn?
Judge, I understand and I see it, but she's got a lot of skin in the game. She's got about, I don't even know how many thousands of dollars of bonds on felonies that she's made. And, technically Alabama's just minor thefts. Realistically, we don't want Alabama to spend the money to come get her. She's going to put up her own money. And you know what? She's going to have not only this bond, she's going to have all those other bonds up in the air. And so she's got a lot on the line, and we discussed that. Now, the failure to appear, Judge, I do just one more argument, was only because she was in jail here. She was keeping up with the Alabama case. Does not bode well the number of cases and types of charges, of course not. But she technically, it was not really a failure to appear. It's just she couldn't go. She has been keeping up with it. Her family is very invested in helping her and got a lot of financial investment. And as a side note, I mean, she's been feeling it. Her sister got shot in the face, 20-year-old sister shot in the face, and she had her funeral yesterday. She missed it. So
that sucks.
She understands like what's been going on, and she's feeling it.
My sister died.
My little sister.
That sucks.
Boyfriend shot in the face was abused. So she's very,
It's awful.
I'm not speaking for you, but is this something where you are committed? And she understands if she doesn't go within 14 days, it's not just this bond, it's everything.
She has an open aggravated robbery of over 65 or disabled. So do I venture a guess that that is allegedly probably taking care of an elderly and she takes a bunch of credit cards and uses them? Is that?
I would have to see if that makes more sense. But Judge, she's also had similar history in other states within the last few years as well. So we wouldn't feel comfortable releasing her on bond. We have concerns that she would be a danger to the community if we did so.
I think so too, Ms. Smallwood. You've repeatedly shown to us that you don't care about our public. You don't care about our bond conditions. And that is evidenced by your 1, 2, 3, 4, 5, 6, 7 open cases here where you have been filed on in multiple dates. And you also have multiple offenses in Alabama, and then you have similar offenses in another state. So essentially, you are playing hopscotch with the states with criminality. And you want me to give you a bond? Really? I would like hair, but I'm not going to get it. That's just a sad fact of life. Like here, it's also a sad fact of life. I'm not giving you a bond because if I let you out, what's going to happen? Historically speaking, every 2 months you pick up a case. So if I let you out in 2 months, you're going to pick up another case. I don't want that to happen. Sometimes we have to protect people from their own selves. You are your own worst enemy. And now I'm going to protect you from yourself. I'm not giving you a bond. I can't trade it.
Understood. Thank
You know what I mean? It'd be, and not only that, all the money she's posted here. 1, 2, 3, 4, 5, 6 $60,000 bond. Whose money is that? All these are credit card abuse cases. She's getting money from somewhere, some other place. No. Sorry, man. You're staying with me. Just let Alabama know that I'm not, so that they can come get her. The good news is that you've made bond on these cases. So we now give Alabama 14 days to come get you. If they don't come get you, then they'll file a dismissal. Or has she waived? Or no?
She has waived. What date did she waive? September 25th.
Yeah. So you have actually 13 days. No way, Miss Smallwood. It's time to pay the piper. Thank you.
This is all gonna be over with by now.
Nope. Nope. All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you. You understand those?
Yeah.
All right. Mr. Barger, do you know how he wishes to proceed?
No, he indicated he would enter something.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that we were gonna say a couple things first.
No.
Okay,
You can answer my questions.
sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, return to sender, and offer to contract is denied. Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments, even after being heard and ruled against. And now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this manner without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Wirgo to represent you as a lawyer.
Okay, let's just do Wirgo here.
If the Office of Assigned Counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute or contribution from Mr. McLeod for the costs of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
We're not good.
all right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Mr. Court wanted to entertain a bond in this matter, Your Honor. To my understanding, Mr. McLeod is a local resident and he has not with the exception of the last court date that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates. All, and he's employed locally. I think perhaps the court would set a modest monetary bond that would ensure future gains.
Make sure.
Mr. Juliet.
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of the court rule. So he's made it clear he doesn't want to take it as serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail. I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize too for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really relied on it. This would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does. And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody to County Sheriff, and will next see you, sir, with your lawyer, Mr. Wordwell.